Good afternoon, everyone, and welcome to the July edition of In the Boardroom, where we are going to talk today about county boards of adjustment. My name is Sarah Diedrich Kasdorf. I'm the Director of Outreach and Member Engagement at the Wisconsin Counties Association, and I have the honor of welcoming everybody to today's segment of In the Boardroom, as well as to introduce our two speakers. Before I do that, I just want to make a couple of quick announcements for everyone. And then we will get right into our programming. So, if you have any questions during the webinar, you can use either the chat or the Q&A function. Input your question or comment in either the chat or Q&A, and Rebecca and Malia will be monitoring that throughout this webinar. In addition to that, the last thing I want to mention is that this webinar is being recorded, and the recording, along with the PowerPoint presentation, will be placed on the WCA website. If you go to www.wicounties.org, on the upper right-hand corner of the screen, there is a blue bar that says WCA Webinars. Click on that, and you will find the recording and the presentation posted likely before the end of the day today. With that, I am going to now introduce our two presenters for today. You will notice we don't have Andy Phillips with us today, even though they are giving him credit on the title slide of the PowerPoint presentation. But we do have the A team with us from Attolles Law. Not only do I call them the A team because they are great attorneys that specialize in county government, but they are also the A team because their names are alliterations. So we have joining us from Attolles Law today, which actually also starts with an A, we have Rebecca Roker and Malia Malone. And they both have lots of experience working with county government. Rebecca has been with Attolles, I think, since the start of Attolles Law, and has worked, I think, even with Andy prior to Attolles becoming Attolles Law. So we've known Rebecca a long time. And Malia Malone has been with county government a long time, spending many years as a county corporation counsel before joining Attolles Law. So you guys are in great hands today with Rebecca and Malia. I am going to sign myself off as I need to hop on to another noon meeting. But again, Rebecca and Malia will take you through all of the ins and outs and everything you need to know about county boards of adjustment. And then they will also be closing out this afternoon as well. So Rebecca, I think you are kicking it off.
I am. Thank you so much, Sarah. Good afternoon, everyone. Thank you for the nice introduction as well, Sarah. Andy was pulled away on a last minute, very important meeting for one of our county clients. So he is not here, but he asked us to extend his hellos. And is obviously we're here today to talk about county boards of adjustment. And from Malia and my perspective, this is a cool topic because it is really self-contained within one statute. We've got applicable case law. And so what we're going to do today is certainly run through the law. But then we're also going to talk in detail about best practices and what we see from our perspective on how to improve county boards of adjustment, and then, of course, answer any questions. As some of you may know, when we represent our county clients in Board of Adjustment matters, oftentimes Malia and I will tag team because I kind of handle the pre BOA matters from a zoning and land use standpoint. And if we get to the BOA, Malia is on our litigation team. And so Malia will then we'll partner at the BOA. So I personally think it's really cool that the two of us are here today. Malia, anything to add before we dive in?
No, but I did see that we had some Polk County folks on, and I just wanted to say hi, everybody. I miss you.
But we're really glad you're at Attolles, Malia. All right. Sorry, Polk County folks. Okay, so jumping in. Oh gosh, there we go. Okay, so quick overview. We're going to talk about a BOA. And when I say BOA, I mean Board of Adjustment. The role in the whole zoning process, We're going to talk about the statutory authority and specific statutory procedures. Now we're going to touch on the typical matters that you're going to see at your BOAs. And then, as I mentioned, we want to leave time to talk about best practices and what we see from our perspective on how you can improve BOA functions and processes and so forth. Okay, so starting with an overview of a BOA's role in the whole zoning process. The statutes require that if a county has adopted a zoning ordinance, it must also have a board of adjustment. And why is that? Because the board of adjustment is really the clearinghouse for appeals. And it is very specifically a quasi-judicial body, which means it applies the rules, policies, law to the specific facts of the case. The BOA is not a legislative body. And that's kind of our best practices, number one, that, the folks that you want to have on your BOA and in the training is a real emphasis on the fact that this is a quasi-judicial body and not a policy-making body. Malia, did you want to jump in there right away? Because that is really one of our best practices that we might as well kind of interweave into our presentation.
Yes, so selecting and training Board of Adjustment members is key because what I have seen going around the state and dealing with certain counties and their boards of adjustment, and I'm not speaking about Polk County when I say this, but what I've observed is Board of Adjustment members, when they're dealing with an appeal, they'll say things like, well, that shouldn't be allowed in that area, when the ordinance already has been adopted and shows that that particular use is either an allowed use or a conditional use. So it's already gone through the process, but they're coming to a meeting and thinking that their job is to decide whether or not this is a good idea to have it as a conditional use, and that's not their role. So that recruitment and appointing of members in whatever iteration that happens, depending upon whether it's a county administrator or executive or administrative coordinator form. So it's a little different. We'll talk about that later. But that selection and education of those folks, making sure they have not only the capacity, but the willingness to know that their lane is not that of the legislative body of the county board deciding what the zoning ordinance should or should not say, that they have to work within the ordinance as it's already passed.
All right. And again, the fact that the BOA is not that policy making body is a theme that is really woven throughout what we're talking about today. So moving on, the BOA has very specific authority over specific matters, and we'll get into that when we start talking about the statute that controls in more detail. And I'm just going to flip here. So our controlling statute is 59,694, and sub 7 is the one that we're going to be talking about specifically. But again, as lawyers, this is really cool because 59,694 is really the one-stop shop for the law that applies to BOAs. Case law has expanded that, but we've got all of what we need to talk about BOAs in that one statute, which includes what the procedures and processes are. So what is the BOA authorized to hear? Again, it's all contained within 59,694 sub 7. Number one is administrative appeals. And that is an appeal where an interested party or an aggrieved party disagrees with an administrative decision, such as your zoning director, or the issuer of a permit, or if a permit is denied from the administration standpoint, or case law has extended that appeal oversight to zoning committee decisions. So again, the BOA is the first stop if an aggrieved party wants to appeal an administrative decision. A BOA also has jurisdiction over variances to hear and decide those. We're going to talk about area and use variances and the difference of legal standards. And then also some BOAs have or they take jurisdiction by their local rules over items like conditional use permits. And the statutes also allow for specifically for variances on renewable energy systems. And as I'm sure some of you know, we've been talking a lot about renewable energy systems and solar energy systems a lot, both within WCA as a whole. Many of the counties are facing these issues. So I think it's interesting that 59694 specifically includes a reference for renewable energy systems. All right, moving on. Malia?
I just wanted to add that, in my opinion, the best practice when you're developing the rules for your Board of Adjustment is to specifically note that decisions of the underlying zoning committee are considered decisions of an administrator. So an administrative decision or administrative officer. That way there's no question as to their authority to hear those appeals from the zoning committee.
Mm-hmm. Yeah, that's a really good point, Malia. And this is something that we have discussed internally, is when you look at the specific language of the statute, it uses that term administrative official. Well, how do we make the jump from administrative official to zoning committee? And we do that by case law. So we know that the BOA can hear appeals from, whether you call it the zoning committee, planning committee, whatever that county zoning agency is under 5969. So what are some of the statutory procedures that we have to follow? Number one, as Malia just touched on, we have to have BOA rules. The statutes specifically require that the BOA adopt rules for its procedures and practices. And Malia, did you want to make any other comments on the rules?
Well, I think when the rules are being set, they're going to be set by the county board for the Board of Adjustment. And I think it's a good practice to, if you have a code, a municipal code, to incorporate those rules directly into the municipal code. So they're readily available not only for the Board of Adjustment members, but to the general public.
Mm-hmm. Yeah, and because the BOA rules are required by statute, they play a more significant role in the BOA procedures than, say, zoning committee or planning committee bylaws, which aren't always adopted into the statute. And so what's the impact of that? A BOA has to follow its rules. It cannot deviate unless that deviation is allowed under those rules. So the BOA rules really have a significant importance in the BOA functioning. So next, the meetings are called by the chair of the BOA as the board may determine are necessary. So oftentimes you will see BOAs don't have standing meetings. They'll be called when there's matters that need to go in front of the BOA. Certainly some counties do have standing BOA meetings if they have a continual flow of items that are appealed. And this next point, that the chair may administer oaths and compel attendance of witnesses. This really starts to get into the authority of what the BOA can do. And this is different than other zoning bodies. And so I think we're going to touch on those powers a little in more detail. So I just want to kind of get through these other specific statutory procedures. A BOA has to keep minutes. It has to show the vote of each member it has to keep a record of its examinations and official actions. That record must be filed in the office of the BOA. Usually the BOA office will be your zoning department office. That's what we see most typically. And then the records of the BOA are also deemed public records under Chapter 19, our open records law. And then under, or any decisions have to be by majority. There's no unique requirements that certain decisions be by either 2/3 or a super majority. We're straight majority decisions at the BOA. Leah, do you want to take out our next slide? We keep going on, or now we're going to jump into what a BOA can do and what powers they have. And this is an interesting place, folks, because this is where we see a lot of errors, or at least I think that's a fair statement, right, Malia?
Yeah.
Perhaps the most frequent error. And we've got one right now that, the understanding the powers of the BOA and what the BOA can do is frequently misunderstood. So I'm going to pass the baton to you, Malia.
Sure. So when we're looking at a review of a conditional permit that was either granted or denied by an underlying zoning committee and it goes to the Board of Adjustment, they can hold what's called a de novo review. In other words, they can start fresh, have a whole new public hearing, and just replace the decision of the zoning committee with their decision on de novo, or they can review the record of the underlying zoning committee decision and reverse that in whole or in part, or affirm it in whole or in part. But one of the things that they are not, they don't have the authority to do is say, we don't know, but we're going to remand this back to the zoning committee for further consideration. So unlike a cert review by a circuit court that we'll talk about later, where the circuit court could remand back to either the Board of Adjustment or another administrative quasi-judicial body, the Board of Adjustment doesn't have that authority to remand back. The other thing to keep in mind is when the Board of Adjustment is reviewing a decision of, let's say, the zoning administrator, again, they can review, or they can reverse or affirm in whole or in part, and then it's kind of like a remand back to direct the zoning administrator to comply with whatever decision that they made. Although we talk about a written decision is not required, as long as you have either a good transcript of the proceedings and it indicates all the rationale for why the Board of Adjustment made its decision, or a audio or video recording of the proceedings. I believe it's best practice if the Board of Adjustment has legal counsel, whether it's corporation counsel or outside counsel, because corporation counsel can be conflicted out of that role if they are representing the zoning committee. And so in those particular circumstances, either creating a form that the Board of Adjustment becomes comfortable with that has sections in it that talk about were the issues, these are the facts that we found, and this was how we applied the ordinance to those facts, and this was our decision, and these were the bases for our decision. That is the best practice, but it is, again, not required.
Malia, I just noticed that we have a question. Fred Strand asked, if a town, city, or village adopts a zoning ordinance, do they also have to have a BOA? And yes, they do. That statutory requirement is not found in 59-694. But if you look at the akin provisions in, I think it's 62, chapter 62, 61, and 60 for cities, villages, and towns, you'll see that same requirement, that if you adopt a zoning ordinance, you must also have a Board of Adjustment. All right, time to flip, Leah.
Sure.
Okay, come on, there we go. All right. You want to keep going on the powers and we're on administrative appeals now, I'm sorry. I love that in the boardrooms that we can be a little bit more casual. So sorry folks that I forgot where we were. Okay, with respect to administrative appeals, again, this is an appeal by an aggrieved person of any officer, department, board, any decision really that impacts that aggrieved person. That appeal may be taken to the BOA via administrative appeal. In administrative appeals, you have to follow the BOA rules in terms of the timing. So the statutes do not set forth a specific time like for other matters, but that time has to be set forth in your BOA rules. To start that process, an aggrieved party would file the notice of appeal with the officer from whom the decision was made. So whether it be the zoning administrator, the zoning committee, whomever that party needs notice, and then the aggrieved party also has to file the notice with the BOA itself. Again, in some counties, those will overlap. The BOA secretary might be the zoning administrator, so you're giving notice, or the aggrieved party is giving notice to the same person but in two separate roles. Next, under 59,694 sub 4 is where we first see the requirement of forwarding the record. And as many of you know, when I'm advising counties on zoning matters, it's all about the record, because if there is appeal, that record is what the BOA is going to be looking at unless it decides to do a de novo review. And so that record is all of the papers, all of the materials, the applications, the audio recordings, any video recordings, anything that the committee or the party making that decision that's subject to the appeal had in front of it. And so, again, because that is the sole basis for the BOA's decision, unless it's doing a de novo review, it is imperative that the county ensures that record is preserved. And then if there is that appeal filed, that record is forwarded to the BOA. Like other meetings, we have to have a class 2 notice for the BOA hearing. Statutes require that the BOA must provide due notice to the parties of interest, which essentially means providing notice within a reasonable time, again, according to your BOA rules of when that hearing is going to be. And then interestingly, the decision must be issued within a reasonable time. As Malia mentioned before, a written decision is not necessary. However, based on the obligations that a BOA has to document the evidence it's looking at, document its facts, and when I say document, it must make those findings. Oftentimes, it is best practice to do a written decision. And so if there is a written decision, that must be issued within that reasonable time. Oftentimes the BOA will make its decision, on the floor, and then there's a written decision that follows. Leah, did you have any other comments on that point?
Well, when we're talking about the written decision, again, if there is legal counsel for the Board of Adjustment, they can assist with that, especially in cases where there's a lot of public interest, where there might be a controversial matter, where neighbors don't want a particular land use or development near their property. And so we've all been there, where the droves and droves of folks come in at the underlying zoning committee, and then they're going to be interested at the Board of Adjustment. And if the Board of Adjustment hears a matter de novo, all of those same folks are going to come in and provide that testimony, and everything that comes into drafting that decision needs to articulate all of the elements necessary. What was the evidence that they relied upon? What was the ordinance language that they were applying? All of those things in a written decision. What I've seen work really well is if the Board of Adjustment makes a decision and makes the record and goes through all of those elements, and then legal counsel drafts and brings that document back to the following meeting of the Board of Adjustment to have them affirm that what the attorney has drafted accurately reflects the decision that the board made. Granted, that is a delay in the decision, which will extend the time for filing an appeal to circuit court. But then at least you're consistent with how those decisions are drafted. In cases where there's not as much public interest, again, that having a form that the Board of Adjustment becomes comfortable with, that helps them know that, okay, we need to come up with our facts. What evidence did we use to make findings of fact? How did we apply the ordinance? Do we have jurisdiction to hear this? All of those things, and then the rationale for their ultimate decision, and applying that again back to the ordinance if there's a form. And we have some that we can share with folks, some templates if certain folks are interested in looking at a form like that.
Mm-hmm. Emily, we have two more questions, and I think we may have just answered the other one. The second question was, no written decision is required, but there is a requirement that minutes and votes are recorded. Doesn't this seem odd? Absolutely. There are specific statutory requirements that minutes be taken, votes are recorded, and the basis for those votes. Why wouldn't there be a written decision required? Not sure. And so, which is why we say it's best practice to have a written decision.
And it could be that in your local board rules, Board of Adjustment rules, that a written decision is required. So when we say it's not required, we're saying that statutorily it's not, but it could be required within your own rules.
Yes, that's a really good point, Malia, that the 59-694 doesn't specifically require that written decision, but oftentimes the specific board rules will. And then our third question is, are there rules in statute for a contact between the plaintiff and the BOA prior to a BOA meeting? I think I understand the question, and the answer is no. There is, and Malia, jump in if you have a different thought, but I don't believe there's anything in the statute that sets forth that contact between the plaintiff or the aggrieved party and the BOA prior to the BOA meeting, other than the due notice that is required under 59-694 sub 6. There's no other statutory requirement that there be like a pre-conference or any other dialogue other than just giving notice of that hearing.
I wonder if the question is more akin to, is there a rule prohibiting what we would call ex parte communication in a court setting, where one of the participants, either the applicant or folks opposed to the applicant's position, try to influence the Board of Adjustment members by sending them letters and emails or that kind of thing. And of course, there's going to be public interest in a lot of these matters because people have concerns about development, especially when it's in their neighborhood. And so that is something that Board of Adjustment members are going to face. And again, that education and training piece, that you cannot consider information that's provided by those interested parties outside of either, if you're holding a public hearing because you're doing something de novo, or it's a variance and there's a public hearing. If the applicant or the other interested parties want the Board of Adjustment to consider information, they need to provide that during that public hearing. And when the Board of Adjustment is reviewing the record of an underlying zoning committee decision, the Board of Adjustment has to rely upon that record and not any external information. So again, it's really important to make sure that our Board of Adjustment members have that knowledge so that if they are influenced by folks trying to lobby them outside of the meetings themselves, that they recognize that that's something that they should avoid.
Yeah, and I think you're spot on, Lee. I think that was probably the point of the question. So thank you for clarifying. What Malia just touched on, I think, is a great example of how a BOA is different than that legislative body. Obviously, as a county board supervisor or as a zoning committee member, you are going to have people reach out to you because you're an elected official. And sometimes those discussions should be disclosed. But here, those one-on-one conversations with the BOA members is totally different. Would you agree with that, Malia? Because again, this isn't a legislative policy-making body. This is a quasi-judicial body. And so that ex parte communication or that outside communication, it just is not supposed to happen as it does with other policy-making bodies, right?
Right. So let's say you've got a Board of Adjustment member in a meeting and they say, well, John Smith, who is an interested party, called me the other day and explained to me why granting this permit would be a really bad idea and said this in the meeting. Then what that Board of Adjustment member has done is given the other side a nugget to claim that their due process rights to a fair hearing before the BOA were violated. So it seem like a reasonable thing to do to listen to somebody who's trying to call you because they know you're involved in a particular matter and you're on the Board of Adjustment. But if we can teach our Board of Adjustment members to say, hey, John Smith, thank you for calling. You can bring all of this information to the public hearing if we're holding a public hearing. And tell me then, but I cannot take any information that you're providing me right now, because then I would be, violating the rules. And it can be hard because especially in small counties, people have relationships, they know people, they're related to people, they have connections. And so they might feel like, oh, I should take this call, and I should listen to what they have to say. And so if we can give them those tools so that they can be respectful and say, I appreciate you contacting me. This is not the appropriate way to get information before the Board of Adjustment. Thank you for the call, but we'll talk to you later and I'll see you at the family reunion, that kind of thing.
Great. One last point on administrative appeals. And I touched on this before. So based exclusive, whoops, it didn't flip. There we go. So based exclusively on the language in 59,694 sub 4, it doesn't include the zoning or the county zoning agency, again, which is the planning committee, planning commission, zoning committee, under 59,694. However, case law has extended that definition of an administrative officer to decisions of that zoning or planning committee. And so that's the link that we get, or how we link a BOA's ability to hear appeals from a zoning committee's decision based on what the statutory language is. So that is clear under the case law. All right, let's move to variances. And Lee, I'm going to let you take the variances.
Sure. So variance is everybody's favorite thing. This is when the lines between the legislative body's authority to make the ordinance and declare what is allowed and what is not allowed sort of bleeds into this quasi-judicial body of the Board of Adjustment. Because what a variance is when the Board of Adjustment is allowed to authorize let's call it a variance, authorize an applicant to vary from the strict terms of the zoning ordinance in certain circumstances, certain limited circumstances, and give some flexibility to citizens to use their property when their property has some unique features. And so there's two variance types. One is an area variance. This is going to be the kind of variance that the Board of Adjustment hears most often, because this is where there is a bit more flexibility. When we're talking about an area variance, we're talking about dimensional setbacks, how far back from the property line or the ordinary high water mark or the height, that kind of thing. And then there's the use variances. And this is when the Board of Adjustment is theoretically allowed to authorize a use that is not permitted by the ordinance. And these are very rare because they're difficult to be granted, and we'll talk about that. All of this is found in 59694 sub 7 sub C. And if you look at that statutory language, it talks about different elements that are necessary for the two different kinds of variances. So if we can zip to the next slide. So the area variance legal standard, the Board of Adjustment needs to make three findings: that the property has unique physical limitations. So we're talking about limitations on size, maybe slope, that kind of thing, and where strict compliance with the terms of the ordinance would cause an unnecessary hardship, and that the variance would not harm the public interest. So the main focus is going to be on that unnecessary hardship. Before 2004, the definition for unnecessary hardship in an area variance was no use of the property. And that was incredibly difficult. And so in 2004, in the Zier-Vogel case, the definition for unnecessary hardship changed from no reasonable use of the property to whether compliance with the strict letter of the law governing the setbacks, frontage, height, bulk, density would unreasonably prevent the owner from using the property for a permitted purpose, or would render conformity with the restrictions unnecessarily burdensome. So in a case like this, if you had a smaller lot that had some slopes, and you're permitted to add, let's say, a septic system, and because of the slope, the septic system is going to need to be placed in a little bit closer to the lot line, and would need a variance from the strict setback, but that would not harm the public interest, and it is because of the unique physical limitations of the property. That's where a Board of Adjustment has the discretion to authorize deviation from the strict letter of the ordinance itself. Now we can go to the next slide. And this is the use variance, and this legal standard is no reasonable permitted use. Conditions unique to the parcel, and it would not alter the essential character of the area. And in all cases, keep in mind that the burden on establishing these things, it's not up to the zoning staff, the zoning administrator, to prove anything. The burden is on the applicant, the one who is seeking to vary from the terms of the ordinance. These are incredibly rare. Because any use variance, so you're saying, yeah, you can engage in this particular use when it is not an authorized use, not a permitted use, not a conditional use. So it's a prohibited use. And this is kind of akin to what we were talking about. Are they policy-making body where they're kind of rewriting the ordinance for this particular applicant, and that burden of no reasonable permitted use. So as long as they could use their property for something, the likelihood of a Board of Adjustment being able to meet or find that the applicant meets that standard is going to be incredibly rare. And so we don't see many of these. I would be interested when we have our Q&A later on to hear stories about use variances in cases where they either have come through and been granted. But again, these are very rare.
I was just typing, Jeff had some questions in the chat, and I'll touch on, I'm going to do a second question first. He says, variance is the exception, not the rule, correct? I mean, I would say yes. Agree, Malia? Yeah.
That's a great way to frame it. It is really an exception, not the rule, because it's an exception to the actual rule. Yeah.
And then Jeff's original, oh, please give an example of this. That was the next question. I'm not sure if, Sue, if you mean an example of the area variance or the use variance. Maybe we'll hold off on the use variance, as you indicated, Malia, is a complete deviation from what is permitted under the zoning code. So an example would be you've got an R1 residential zoning district, and use. Okay, you've got a residential zoning district, and the permitted uses are single family, multifamily, and home-based businesses. Okay, conditional uses are I don't know, small businesses where no outside parking is needed, okay, let's just use those. So we've got a set of permitted uses, and we've got a permitted conditional use. But if I want to open, if I want to have a park in my backyard, that would be a use that is not permitted as a permitted use or a conditional use. It is a complete variation or deviation from what is allowed either as a permitted use or a conditional use in the zoning code, right? So I'm totally going off the rails in what is allowed in the zoning code. That's an example of a use variance. So if I wanted to open a park in my backyard and it's not a permitted use or a conditional use, that begs the question of why would we have zoning? Because we want an orderly development of land use. And the whole point of that zoning code is to implement that orderly development. And so when someone's asking for a use variance, it is literally deviating completely from what that code requires. And again, that's why we see that very high threshold of no other reasonable use. In my example of the park in an R1, clearly I have other available uses in my R1. I already have a house there. This is the backyard. I don't need it to be a park. And so that if that was requested as a use variance, it should be denied.
And that's why these are so rare, because it is hard to imagine what situation would give rise to a circumstance where the Board of Adjustment could find, yep, there's no other reasonable use for this property.
Mm-hmm.
And there's maybe, I mean, there's no recent case law addressing use variances. And so I think that is because if they're applied for, they're most likely going to be denied because there are such limited circumstances. That's why it's hard for us to come up with an example of what would qualify as a valid use variance. But it is authorized within the statute. The burden is just extraordinary.
And that is a good segue, not only to our next topic, and the next comment we have from Kimberly. Um, I realize use variances are recognized in the law. This seems to be a more recent development in the last 10 to 20 years. In my opinion, there's no such thing. It is a rezone, not to be determined by the BOA, but rather by the legislative body. And I agree with you, Kimberly. Because of that high threshold, it's really, yes, it's available under the statutes, but I can't think of an example where uh, it would be used. And I think part of that being our next topic, which is special exceptions and conditional uses. Um, the law regarding special exceptions and conditional uses has evolved in such a way that conditional uses are utilized far more in zoning codes than they used to be. The fundamental theory of a conditional use is that you've got a set of permitted uses in your zoning district. And if there's a use that makes sense, again, residential district with a home-based business, you're providing childcare out of your home. That makes sense, right? You don't want to allow a home-based business as a permitted use with no additional regulation, but it makes sense that you might want to allow that other use, that home-based business, if there are specific conditions applied to it. That function of a conditional use is really, in my opinion, what that use variance is trying to address. And so from my perspective, there's other remedies at law if you've got an owner or a user that wants to engage in a use that is not permitted exclusively by the zoning code, i.e., that would be a conditional use, or as you mentioned, Kimberly, a rezone or some sort of land division or some other mechanism by which that user can accomplish that desired use. So with that segue, let's touch on special exceptions and conditional uses. Again, as I mentioned, these have really evolved in the last few decades as a more frequently used tool. And so some BOAs still see or still hear special exceptions and conditional uses. Why? Because technically they are deviations from the zoning code. However, because of that evolution of the use of a conditional use, oftentimes you will see conditional use permit requests go to your planning committee or your zoning committee. And so that, again, under 59, it's the county zoning agency, i.e. the planning committee or the zoning committee, is going to be the body that hears that conditional use permit request. But just wanted to touch on that there are still some counties out there that have special exceptions and conditional use permits go directly to their BOAs. All right. Let's touch on certiorari review in two different contexts. Number one, well, Malia, I'm going to let you take the appeal via the writ of certiorari because that's definitely in your litigation court. So I'm going to let you take that, and then I can tackle the standard if you want.
Sounds great. So when a decision of the Board of Adjustment is appealed to the circuit court, it is that writ. It's not like a regular pleading where you've got summons and complaint and answer, although you can file a writ using the summons and complaint format. What this is doing is saying, hey, circuit court, we need you to review the decision of the Board of Adjustment because we think one of three things. We think the Board of Adjustment did not have the jurisdiction to hear it. The Board of Adjustment made its decision based upon its will rather than its judgment. And that's the circumstance where you get a Board of Adjustment member that says on their record, yeah, I just don't think that use should be a conditional use at all in this county. So I'm voting no. Well, They substituted its will rather than its judgment applying the ordinance. And whether their decision was based upon substantial evidence. And the substantial evidence is not like a clear, satisfactory, and convincing or beyond a reasonable doubt. It's just whether or not a reasonable Board of Adjustment, given the same information, could have come to that decision. Even if the circuit court judge thinks, wow, I probably wouldn't have made that decision. The circuit court judge doesn't get to substitute its judgment for the Board of Adjustment. All they can do is determine whether or not they operated on the correct theory of law and had jurisdiction, whether there was substantial evidence that could be used to support the decision, and whether the decision represented its will rather than its judgment. And most of the time, if the circuit court ultimately determines that, hey, they didn't apply the ordinance, so they operated under the incorrect theory of law or substituted their will rather than their judgment, they're going to remand it back. In other words, send it back to the Board of Adjustment to redo their decision and apply the appropriate standard within the ordinance. However, they're not required to do that. The circuit court can affirm the decision of the Board of Adjustment if they believe that it satisfied all of those elements, or they could reverse in whole or in part. But again, what I've seen throughout the state generally is the circuit court is going to remand it back to the Board of Adjustment. Usually there's no new evidence taken on a writ of cert. However, there have been times when a party will file a request to substitute the record, supplement the record. That's very rare. So again, just like keeping the zoning committee and their record in a manner that is accessible and accurate, it is again important for the Board of Adjustment to maintain its record, because that record is the only thing generally, other than lawyers' arguments, that the circuit court will use determining whether or not it's going to affirm, reverse, or remand the decision of the Board of Adjustment. And deciding what is in the record can sometimes be difficult. So in counties where you have an experienced zoning administrator or experienced staff within the zoning office that can be given that duty of making sure the record is compiled at the time that the hearings and meetings occur. So that is a record of any written information that is presented to the Board of Adjustment, any exhibits that are submitted to the Board of Adjustment, including photographs, maps, anything that was included in the original application. And again, the minutes and information provided to the Board of Adjustment, and keeping that in with an index of Exhibit 1, Exhibit 2, all of that. If you can keep that together from the beginning, when and if there is a writ of cert to the circuit court, the Board of Adjustment is going to be in a much better position to compile that record and send that off to the court. And that can sometimes be, a pretty heavy lift, especially when you have cases that have significant public interest, a lot of testimony, a lot of exhibits, a lot of letters and emails that are submitted and given to the Board of Adjustment or read to the Board of Adjustment. All of that has to be contained within the record.
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 Next question, John, your question regarding unnecessary hardship. I'm going to jump back to that one and just quick cover Alan's question. Will you cover site visits by the BOA and what is the correct activities to do at the on-site visit? So this kind of is a segue to our best practices. A BOA can do a site visit. However, if they do it as a group, that is a meeting that has to be publicly noticed under Wisconsin's open meetings law. So yes, you can do a group site visit. And then the information gathered from that site visit becomes part of the record. Certainly, we recommend coordinating with the owner. So it's, the owner should be receiving notice of that meeting, but then also, approving the time so people don't just show up, at the parcel. And if the BOA members make that site visit individually, unless you've got a quorum, it's not a public meeting. That does not need to be publicly noticed. However, that board member should state in the discussion that they made a site visit. And here's the information that they gathered as part of the evidence for the record, in reporting back on that site visit.
And I would just say, and this is my personal opinion, if you have the ability to rely upon zoning staff to conduct the site visit, provide photographs or video, and then public information at the meeting about the site, rather than having a site visit, that is, and as long as the Board of Adjustment feels that they have enough information, I would suggest doing that, trying that first, and then adjourning and for a date certain to a future meeting for a site visit, only if they determine, hey, we need more information about the site visit, because then you don't have to worry about noticing that as a public meeting and worry about other members of the public, especially in a controversial circumstance where they're going to show up to this person's property and there could be other issues. So while they are permitted, I think it's best practice to try to avoid them as long as the board can get the information by other means.
That's great. Okay. Whoa, what did I do? Can you still see my screen, but in a different mode?
Yeah, it just...
Okay, I'm just going to jump down to best practices. Okay, so we've got a few minutes left. And a lot of these we've touched on as we just integrated the best practices into our presentation. The membership, the statutes allow no more than 5 members. You have to have 2 alternates. That is for populations with less than 750,000. If you have a county administrative coordinator form of government, the county board chair appoints the members with county board confirmation. Under the county administrator or county executive form of government, that individual appoints BOA members with county board confirmation. So,
and just to note, Rebecca, that the members, there's geographical restrictions on membership to the Board of Adjustment. So that's another thing to keep in mind. They can't be from the same area. And so that is meant to make sure you had a representation from across the county.
Yes, great point. Thank you, Leah. And then in selecting these BOA members, in talking about this, we came up with these 4 as not maybe the most important, but really important to remember in the kind of job description. What is the person's experience? It doesn't have to be a land use background, but that can be helpful, or an individual that has experience in architecture, engineering, real estate, even accounting. I mean, kind of that diverse background and experience can be really helpful. Again, expertise in land use is not a requirement, but it can sure be helpful and beneficial. It is so important for BOA members to appreciate that nonpartisan role, that they are not there as policymakers. They are there to apply the law and the rules to that set of facts. And so, how you vet that in finding, the best BOA members can be a challenge, but it's definitely something that should be kept in mind. And then also just that desire to serve the public. Being a BOA member it's a huge time commitment. Again, because of the statutory obligations placed on these BOA members and the volume of information that they have to review, somebody really, needs to have that commitment to public service to do a really good job. Training is so important for BOA members. BOA members should have a good understanding of what laws need to be applied and all of those statutory procedures that we talked about. So training is key. Couple others, have some dialogue between your zoning committee, your planning committee, and the BOA. The BOA is oftentimes the reviewer of that zoning committee work. And if there's trends or there's places that BOA members feel could be improved upon, either in the ordinance or at the zoning committee, let's have some dialogue. Let's have some feedback. So, so we can improve the process. And then also, just briefly, I think we do have some other questions. BOA members, even though they are in more of an isolated role as nonpartisan, non-policy making body, they can certainly participate in that comprehensive plan process and in the actual development and review of ordinances. They don't have a statutory role per se, but they can certainly participate in that process. To the extent, obviously, that it doesn't cause any sort of conflict of interest. But again, that underscores the training piece of this, that our BOA members have to have that experience and have to have that training. So those are just two examples of how that can occur. All right, we're at 1 o'clock. Malia, can you stay on so we can finish our questions?
Absolutely.
Okay, if anyone has to jump off, you can feel free to email me or Malia or Andy or WCA with your follow-up questions. We'd be happy to answer those. And again, for the people who have to jump off, thank you so much for joining us. And we will see you in the boardroom next month. But again, we will stay on to answer these remaining questions. So the next one is just a comment from Alan. I don't like getting into a change and request at the site. Great point, Alan. Another reason why site visits can create precarious situations. And so I totally agree with Malia that let's avoid those if we can.
Well, the other thing to avoid if there are going to be site visits is to either drive separately or make sure that when they're in a vehicle going to the site, that they are instructed not to talk about the matter, not to talk about the application or the issue, because that would be an open meetings law violation. So again, either drive separately or take a vow of silence or talk about anything but the zoning issue at hand.
Yeah. Ellen had a follow-up question. The BOA visits every site before the hearings to get a view of the property, including setbacks from water, side lot, and steep slopes that come into play. Is this wrong? No, it's not necessarily wrong. If that's what the BOA chooses to do, the BOA can do that. Just make sure that if they're going in a group, that has to be publicly noticed. And with those other challenges, as Malia just mentioned, if they are traveling together in a van, they cannot talk about the issues at hand because that's part of the public meeting. Then there's, the issues of accommodations, making sure that the public has access if this is a publicly noticed meeting. So yes, your BOA can do those site visits. It's just a question of the how. If BOA members are instructed to look at the sites individually before each hearing, certainly they can do that. And then you're not at a public meeting. So that kind of solves the public meeting issue. I would still recommend coordination with the property owner. So, if that BOA member wants to actually get on the property, that there's, that understanding with the owner that members are going to be looking at the
But again, in a circumstance like that, I would be wary of the property owner walking the property with the Board of Adjustment member and trying to provide information or persuade the Board of Adjustment member, in that circumstance, and give information that is outside of the public meeting. And so if the person who asked the question, if they're going to the properties and that is not noticed in an agenda with the approximate times that they're going to be at each property, that would be likely an open meetings law violation. If they're going, all together as the Board of Adjustment. It has to be reasonably accessible to the public. So if it just says site visits starting at 9 a.m., convening then at noon at the county building, but it doesn't list what order they're going to the sites, the approximate time they're going to be at each of those sites, that would be a problem. If they're going to look at slope, setback, all of those things, that should be something that if they have the staff at the zoning, within the zoning department to conduct those site visits and provide that information at the meeting, that would be ideal. And then only adjourning to a date certain or postponing to a date certain for a site visit in those cases where the Board of Adjustment ultimately determines, hey, I think a site visit, because this is such a unique property or complex situation, a site visit is necessary. And then the public will have advance notice of that site visit. It won't be in conjunction with a bunch of other site visits with varying times. And so I would say that would be, if there's going to be a site visit, the best practice.
Okay.
And I have had cases involving the site visit situation specifically, where the folks opposed to a particular permit were not able to discern the time in which the site visit on a particular property was going to occur. And therefore, they alleged that the meeting was not reasonably accessible under the open meetings law. So in order to avoid that, I'm very skeptical of site visits except in extraordinary circumstances.
Okay, Ellen had a follow-up comment. Notices include all of the times and places, including sending notice to area property owners next to the site. Okay. All right. Next question. John, I still have to give John. Yeah, let's do John's question. Can you discuss the requirement from subsequent court decisions that have imposed a fourth element in addition to unnecessary hardship, unique physical limitation, and no public harm, which requires the board to balance the public interest in the applicant's hardship? Lee, I'm going to let you take that one because I believe that's a variance question. Malia,
Sure.
can you see the question and answer in the?
It does not pop up on my screen.
Okay, if you go to the bottom where it says Q&A, just because that's kind of it's a longer question, so I wanted to make sure you could see.
Okay. Oh, so I was looking at the chat and I see the Q&A. Okay. So then we go down.
1241, so it's kind of in the middle. I waited on that question because it was a longer one. And for our audience, it's, can you discuss the requirement from subsequent court decisions that have imposed a fourth element in addition to unnecessary hardship in variance request, unique physical limitation, and no public harm, which requires the board to balance public interest with the applicant's hardship?
John, I wish I could unmute you because I cannot answer that question. So I will look into it and I will provide some follow-up information that we'll provide to WCA so that can get out to folks.
Yeah, and I'm with Malia. I don't even want to guess to speak on, how or to the extent that a court has imposed that fourth element. It makes sense though that when a BOA is trying to determine necessary hardship, that it not be looked at in a vacuum, and if there's other compelling reasons such as those public interest or public welfare reasons, that be incorporated as part of the discussion. It makes sense to me, but again, I don't know the specifics of what what that case law gives us in detail. Okay, let's see. You're welcome, John. Always good to see you on. Make sure I didn't miss any. Edward asked, do these same rules apply to shoreline ordinances? And Malia, I believe that, well, yes, to the extent that the shoreline decision or the decision under the shoreline ordinance falls within the administrative official, the zoning committee, or whatever it is that they're looking at under that initial jurisdiction of the BOA. Now, obviously, with shoreline ordinances, there are different rules that apply based on Chapter 281 and NR 151 and all of those other bodies of law. But if a matter or that aggrieved party has a shoreline ordinance component as part of its appeal request, the BOA can hear that component. Would you agree with that, Malia?
Yeah, that's correct.
Okay. All right. I think we got them all. I don't think we have anything. I think we got them all. And again, if we did miss any, please email Malia, me, Andy, or WCA, and they'll forward the questions. Just closing, thank you all so much. Thank you for the great questions as well. It's great to be here. Malia, any other closing thoughts?
No, I just appreciate being able to do this and connecting with folks. And if we can be of any assistance, that's our goal, to help counties.
All right. Well, thank you, everyone, and have a great rest of the afternoon. Stay cool if you're in the hot weather. Take care, everyone.